Right now, as you are watching this video, there are more than 4 million people sitting in a line for a family-based green card. 4 million people. And for hundreds of thousands of them, people with approved petitions, people who followed every rule, people who have been waiting not for months but for years and in some cases for decades, the March 2026 Visa Bulletin just delivered the same devastating non-answer it has been delivering for months. No movement, no forward progress, nothing changed. If you have a family member waiting in the F3 or F4 preference category, or if you yourself are the beneficiary of one of those petitions, what I am about to walk you through in the next 12 minutes could be the most important immigration update you watch this year. There is a specific dynamic playing out right now between the State Department, the National Visa Center, and consular posts overseas that most immigration channels are completely missing. And if you do not understand what is actually happening, you could make an administrative mistake right now that sets your case back by months or longer. Stay with me through this entire video. Welcome to Immigration Path USA, the channel committed to being the clear voice in a space full of rumors, misinformation, and fear. We break down complex immigration policy into accurate, understandable, and actionable information so that you can make informed decisions about your family's future. Before we go any further, I need to be upfront with you. I am not an attorney. Nothing in this video constitutes legal advice. This content is strictly for educational and news purposes only. Every immigration case is different, every family situation is unique, and you should always consult with a licensed immigration attorney or an accredited representative for guidance specific to your case. What I can do is help you understand the system clearly so that when you do speak with a professional, you are not starting from zero. Now let us get into what is actually going on with F3 and F4 in 2026 and why the backlog in these categories has become one of the most heartbreaking realities in the entire American immigration system. Let us start with the foundation because if you are new to these categories, or if you have a family member who is just beginning to understand what they signed up for, you need a clear picture of what you are actually dealing with. The F3 preference category covers married sons and daughters of United States citizens. That means if you are a U.S. citizen and your adult child is married, you can file a Form Y-130, Petition for Alien Relative, to sponsor them for a green card. The F4 preference category covers brothers and sisters of U.S. citizens. Same form, same process at the front end. You file the I-130, USCIS adjudicates it, approves it, and then the clock starts ticking on what can only be described as one of the longest waits in the legal immigration system anywhere in the world. Here is why. Congress set the annual numerical limits for family preference categories under the Immigration and Nationality Act. And those limits have not been meaningfully updated in decades, despite the fact that the U.S. population has grown dramatically. The immigrant population has grown dramatically, and the demand for family reunification visas has grown exponentially. The total pool of family preference visas available per year sits at roughly 226,000. That number gets divided among 4 preference categories and then subdivided further by country of chargeability. And this is where the system becomes genuinely cruel for people from high-demand countries. For a beneficiary from the Philippines waiting in the F4 category, the current cutoff date in the March 2026 Visa Bulletin is sitting in the early 1990s. That is not a typo. The State Department right now is processing F4 petitions from the Philippines that were filed approximately 30 years ago. 30 years. A child who was born the year that petition was filed is now a fully grown adult with their own career, their own family, and potentially their own children. And the original petition is still waiting. For Mexico, the F4 category is similarly stalled deep in the mid-1990s. F3 for Mexico is also significantly backlogged. And even for what the State Department calls rest of world, meaning all countries not subject to per-country oversubscription, like Mexico, China, India, and the Philippines, the F3 and F4 categories are still years behind current filing dates. But here is the catch that most people are missing right now. The March 2026 Visa Bulletin did not just fail to advance these dates. The lack of movement is telling us something specific about what is happening inside the pipeline. When the Visa Bulletin stalls like this for multiple consecutive months, it generally signals one of 2 underlying conditions. Either the State Department is approaching the annual numerical ceiling for visas issued in these categories and is deliberately holding the dates to avoid overuse before the fiscal year ends, or there is a compounding backlog at the National Visa Center and at U.S. consular posts overseas that is slowing the processing of cases that are technically current. In 2026, both of these pressures are present simultaneously, and that combination is creating a squeeze that is hitting F3 and F4 beneficiaries especially hard. Let us talk about how the pipeline actually works, because understanding the mechanics of this system is what separates people who manage their cases effectively from people who get blindsided by administrative delays that were entirely preventable. When a U.S. citizen files an I-130 for a sibling or a married adult child, USCIS receives the petition and begins adjudication. When the petition is approved, the beneficiary receives a priority date, which is essentially their place in line. That approved petition is then transferred to the National Visa Center in Portsmouth, New Hampshire, which is the State Department's centralized processing hub for immigrant visas. The NVC holds the case until the beneficiary's priority date becomes current, meaning until the cutoff date in the monthly Visa Bulletin has advanced far enough to include the month and year of the original filing. For the vast majority of F3 and F4 beneficiaries from the Philippines, Mexico, and other high-demand countries, this waiting period is not a matter of months. It is a matter of decades. And during that entire period, the petitioner in the United States and the beneficiary overseas are responsible for making sure their information stays current in the NVC system. This is where a staggering number of cases silently derail. This is where it gets critical for anyone waiting on a green card in these categories. People file their I-130, receive their approval notice, and then, because nothing visibly happens for years, they stop paying attention to their case. They move, they change phone numbers, they change email addresses, they go through life changes, marriages, divorces, job relocations. And the NVC, which does not proactively chase petitioners down, eventually sends a case initiation notice to an address that no longer exists. The notice goes undelivered. The case goes into an administrative hold. And months or even years can pass before anyone realizes what happened. This is not a rare edge case. Immigration attorneys and accredited representatives deal with this situation constantly. It is one of the most common and most preventable causes of unnecessary delay in the family preference system. And given that the March 2026 Visa Bulletin is showing no movement, right now, today, is exactly the right time to verify that your contact information with the NVC is current and accurate. I want to pause here and tell you about a family whose story captures exactly what we are talking about in a way that numbers alone cannot convey. Elena is a naturalized U.S. citizen who was born in the Philippines and came to the United States in the early 1990s. She worked hard, built a life, and became a citizen in 2002. The day she took her oath of citizenship, one of the first things she thought about was her younger brother, Danny, who was still living in Manila with his wife and their 3 children. That same year, she filed a Form I-130 for Danny under the F4 preference category. She hired an attorney. Everything was done correctly. The petition was approved. The file was transferred to the NVC. And then Elena waited. Danny's children grew up watching their father talk about the day the family might move to America. The oldest eventually came to the United States on a student visa, earned a degree, built a career on an H-1B, and has his own green card application pending through his employer. The youngest is now 23 years old. She was not yet born when Elena filed that I-130 petition. In 2020, the NVC sent a case initiation notice to Elena's address. But Elena had moved in 2019 following a job change. The notice was returned to sender. The case was placed in a documentation hold. It was not until a friend mentioned the CEAC portal, the Consular Electronic Application Center at ceac.state.gov, that Elena realized her brother's case had been sitting idle for over a year, waiting on documents she never knew had been requested. Elena updated her address, resubmitted her affidavit of support on Form I-864, went through the NVC document review process, and eventually got the case back on track. But a year had been lost. A year in a line where every single month is irreplaceable. And as of early 2026, Danny's priority date still has not become current. The system has held this family apart for more than 20 years, and it is not done yet. That story is not exceptional. It is Tuesday in the world of F3 and F4 immigration. So let us talk about what you can actually do right now, because this video is not just about understanding the problem. It is about giving you a framework to protect your case while the system does what it is going to do, regardless of anyone's frustration with it. The first step is verification and contact hygiene. If you are the U.S. citizen petitioner, you need to log into the CEAC portal at c8cots.state.gov today and confirm the status of the case. You should also call the National Visa Center directly at 603-334-0700 to verify that the contact information on file for your case matches your current address, phone number, and email. If anything has changed since you filed the original I-130 or since you last communicated with the NVC, update it immediately. Do not assume your information is current, confirm it. This single step has saved countless cases from unnecessary delay. The second step is financial document preparation. Even if your beneficiary's priority date is years away from becoming current, the NVC will eventually require a fully completed Form I-864, Affidavit of Support, along with supporting financial documentation. This includes your most recent federal tax returns, your W-2s or 1099s, current proof of employment or income, and documentation of your domicile in the United States. The income thresholds for the I-864 are based on federal poverty guidelines, which update every year. If you are currently below the income threshold, this is the time to explore whether a joint sponsor is an appropriate option for your case. A joint sponsor is a separate individual who agrees to be financially responsible for the immigrant and who independently meets the income requirements. Getting the situation sorted out well before your date becomes current means you are not scrambling when the NVC finally calls. The third step is scam awareness. And I want to be very direct about this because the slower the Visa Bulletin moves, the more aggressive the fraud ecosystem becomes. Every time there is a period of stagnation in the bulletin, social media fills up with services claiming they can move your priority date forward, expedite your consular interview, guarantee approvals, or use special connections to accelerate your case. They cannot do any of these things. Priority dates are determined entirely by the State Department based on numerical supply and demand. No private consultant, no notario, no social media personality has any ability to advance your place in the line. Anyone telling you otherwise is taking your money and potentially putting your case at legal risk. Only work with licensed attorneys or accredited representatives recognized by the Board of Immigration Appeals. Now let us zoom out and talk about the bigger picture, because if you are in an F3 or F4 queue, you deserve to understand why the road ahead looks the way it does and what realistically could change it. The backlog you are living through is not primarily a processing problem. It is a structural problem built into the law itself. The per-country numerical caps that cause beneficiaries from the Philippines, Mexico, India, and China to wait decades longer than beneficiaries from other nations are codified in the Immigration and Nationality Act. They cannot be changed by USCIS policy updates, by executive orders, or by directives from the Department of Homeland Security. The only entity that can meaningfully address the structural backlog and family preference categories is the United States Congress, and Congress has not passed comprehensive immigration reform in over 30 years. The current political environment in Washington makes significant legislative action on family immigration relief unlikely before 2027 at the earliest. The administration's immigration focus in 2025 and 2026 has been concentrated almost entirely on enforcement, border policy, and reductions in certain visa categories, rather than on expanding access to family reunification pathways. Advocacy groups representing Filipino American, Mexican American, and other immigrant communities continue to push for reform, but the legislative math is not currently in their favor. What this means practically is that the F3 and F4 backlogs are not going to be resolved by any action in Washington in the near term. The priority dates will continue to move slowly and sometimes not at all. The best and most powerful thing you can do right now is make sure that when your moment comes, and it will come, your case is administratively perfect. Your documents are ready, your contact information is current, and you have not wasted a single day on a preventable delay. If you want accurate, fast, and reliable immigration updates, subscribe to Immigration Path USA right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It is essential.